Hi, good morning, everybody, and welcome to our webinar. My name is Jeff Ruddell, and I'm one of the VAT Senior Managers here at James Cooper Creston. Today's webinar is about VAT mitigation for charities, and my colleague, Georgia, will be assisting with the slides. Firstly, we will be looking at the VAT issues of a grant or contract, and secondly, we will have a review of the HMRC term non-business and the impact on VAT recovery. Finally, we will have a quick look at the goods and services that can be purchased without VAT by a charity. Please note we won't actually have a live Q&A for this webinar, as we find with charities issues can quickly become complex and it would be better to deal with the queries arising on a case-by-case basis in a confidential manner. But we are certainly open for contact either directly to myself or via the JCK website if you need some clarification or assistance. So slide 3. But what is a charity for VAT purposes? So we start with a quick review of what HMRC consider a charity. So HMRC have some basic conditions for a body or an organisation to be considered having charitable status with HMRC. The relevant body must be based in the UK, Isle of Man or EU member state, established for charitable purposes only, registered with the Charity Commission or a similar regulator if outside the UK, or a not-for-profit body is recognised by HMRC. But it should be noted with this final point, a not-for-profit body, otherwise known as an NFP, does not automatically have charitable status and may not be registered as a charity with the Charity Commission itself. However, it can still apply to HMRC to be treated as a charity for tax purposes. And we do have a number of clients in such a situation, including community benefit groups that provide welfare to children. Next slide, please. So let's have a quick look at the VAT issues around income from a grant or a contract. So why is it important to distinguish this? Well, common questions for charities: what is my income? Is it a grant or contract income? And this is important as there are different VAT consequences for grants and contracts. A grant is generally considered outside the scope of VAT, whereas a contract will have a specific VAT liability. So if a charity receives grant funding, this income is normally considered outside the scope of VAT if the grant is freely given without goods or services provided. But you must bear in mind there's not a clear statutory definition for a grant, but normally it does not give rise to any particular benefit or supply to the grantor. And with a grant, VAT would not normally be due. For a transaction to fall within the scope of VAT and therefore become a taxable supply, there must always be a supply, a consideration, and a direct link between the two. So we can move on to the next slide, where we talk generally about the characteristics of a grant and a contract. So the written terms of grants can make them actually difficult to distinguish from contracts, but it's important all parties agree at the outset the nature of the relationship, so it can be reflected in any documentation. So there are a number of points or characteristics that will help in deciding whether payment is consideration for a grant. But please note, this should never be regarded as a tick list, but just really a summary of indicators. So does the grantor receive anything in return for the payment? Was the payment made following a grant application process run by an organisation that regularly provides grants? Or what does the donor receive in return? Secondly, are there any conditions attached to the payment beyond that of merely mentioning it in the accounts? The funder should not be attempting to control how the money is spent beyond ensuring that the funds are properly managed. So any monitoring should be no more than simply ensuring payments are appropriately spent. So what will the payments be used for? Often, the funding is drawn down by the supplier as a reimbursement of expenditure incurred, rather than an advance payment for services. If the funder does not benefit directly, does any third party receive a benefit? Well, the funding may be provided sometimes under a statutory provision that empowers the funder to make a grant. This would normally be relevant if the funder is a government department or a local authority. So a quick look at some characteristics in relation to a contract. So is the funder seeking advice? In effect, who initiates agreement? If the funder is seeking services in return for their payment, then this indicates the payment is consideration for a supply. In essence, the funder believes they're receiving something in return for the payments being made. Is there any contract, commercial in nature, linking supply and consideration? This would obviously indicate it's a legally binding contract connected to a business activity. Is there any sort of payment schedule based on activity points? So does each activity carried out give a rise to a specific and identifiable payment? This may be a single payment or periodic based on work done. And for this to happen, there's normally a record-keeping system. So in essence, leading to a contract situation. And finally, the comment we have here is about the funder control of expenditure. So maybe a funder will indicate they want specific targets in terms of quantity, quality, timeframes, etc. And these are another indication of a contract. And the supplies themselves are probably considered as being undertaken as an economic activity. Can we have the next slide? Next slide, please. There are a number of other grant considerations we want to just have a quick word about. So can a recipient of a grant claim input tax in full? Well, lots of new bodies are often initially funded by grants, and we do look at these in terms of medical research, bodies such as bodies funded by the government agency Innovate. But quite often they can still have full VAT recovery if the grant allows them to commercially exploit or use the research in the future to make sales of the fees. So in effect, there's a product development situation. Sometimes this could just be an IP gained, intellectual property rights, or experience of working in this area to gain skills and knowledge to develop products. Sometimes we do find the HMRC officers themselves have issues over grant income and automatically consider it outside the scope and restriction of input tax recovery. Because quite often grant income is considering as related to non-business activities, but it should be noted this is not the case. But it is correct that there is no input tax recovery if the relevant body will never use the grant-funded activities to make onward taxable supplies. So we're always looking for an economic outlook. Normally with such a case anyway, HMRC would not allow VAT registration. So in order to ensure VAT registration, any body will need to present evidence to HMRC. And this may include cash flow, business plans for commercial income, or there may be evidence of other previous grant-funded projects that have created a fee income, or an explanation of opportunities in relation to future income. Sometimes we look at kind of grant flow down to other parties. Now, this really refers to situations where there's often collaborative research, and where several independent bodies come together to lodge a single grant application. There may be no formal joint venture or partnership contract. But quite often, the application will normally list all those involved, and the lead grant body will receive the whole grant and distribute accordingly. This may be the case for the benefit of administrative fees. In such situations, the subbie, as we'll call them, is not making a supply of services to the lead grant recipient, but rather there is a grant flow down from the lead partner to other bodies. Next slide, please. So in summary of the previous slides, the indicators described should not be seen as being decisive on their own, but in essence, the more grant-like features that there are, the more likely the payment is outside the scope of VAT. So we could say with the grant, freely given, with no expectation of anything in return, grants are not consideration for any supply and are outside the scope of VAT. In a contract, one party makes a supply of goods or services, and one party pays consideration for these supplies. So on most occasions, it can be fairly straightforward to determine. The key point is whether the recipient of the grant funding supplies goods or services back to the grantor. If not, it's very likely to be a grant and outside the scope of VAT. And if yes, it's more likely to be a contract for a supply of goods or services. But you have to be aware that if you get it wrong, you could be in a situation where you lose 1/6, in fact, to 20% of the monies received if a VAT charge is suddenly, if HMRC determine that a VAT charge is actually due and you don't have any agreement with the grantor to pay that amount. We'll move on to the next slide, please. As I said at the start, we're going to have a quick look at activities that HMRC term non-business and the impact of VAT recovery. So quite often the interpretation of non-business is the idea that there's a commercial motive test for a charity conducting a specific activity. So generally a supply of goods or services made in the course or furtherance of the business is subject to VAT, unless of course it relates to an exempt activity, although that is still a business activity. Business itself is not defined in law, and even activities that only cover costs are still regarded as a business. In the normal business world, companies often run loss leaders, supplying goods and services at a loss. but still regarded as part of their overall business activity. So a charity does need to establish if its activities are business or non-business, and in general, is there any economic activity being conducted. Now, it should be noted that HMRC have their own viewpoint, which is based on rules and regulations in UK law, the findings of tribunals and High Court decisions, and Court of Appeal decisions. It's also the case that even though an activity may be performed for the benefit of the community or in the furtherance of charitable aims and objectives, it may still be deemed a business activity for the purposes of VAT. In their own guidance, HMRC do actually suggest a range of questions to ask yourself when considering the relevant activity. And these are sometimes referred to as the Fisher test and are based on a very old VAT tribunal case. So what we've talked about there with the Fisher test is, well, the quick summary of the case is Lord Fisher ran a shoot on his estate, to which he invited friends and relations. The shoot itself was well established and was seen as a society event, and traditionally it was being put on for free. Obviously, with such an event, costs increased, and around 1977, he started making charges to participating guests of around £1,500 per person, but these were described as contributions. Now, Lord Fisher was registered for VAT in respect of his estate, wildlife park, and various commercial receipts. So both sides accepted that in granting guests the right to shoot, a supply was being made. The question was whether this was made in the course or furtherance of the business. At a VAT tribunal, Justice Gibson rejected HMRC's contention that it was a business, and the tax should therefore be accounted for on the contributions. In his judgment, he reviewed the tests applied in all cases and concluded that in putting on a shoot that was previously free, Lord Fisher could not be said to be predominantly concerned with the making of taxable supplies for consideration. Now, HMRC in their own guidance, in Notice 701/01 by How VAT Affects Charities, they've provided some indicators themselves of what to determine a business test. So what we have is a predominant concern for making taxable supplies for consideration. So in effect, are business sales being made? Are the activities themselves a serious undertaking earnestly pursued? Is there reasonable or recognizable continuity? Are these one-off events? Is it an ongoing process? Is there a measure of substance in regard to the annual taxable supplies? In effect, what we're asking there is how much is involved with these supplies? And is the activity conducted regularly and sound business principles or on regularity? If it is established there's a sufficient link between the supplies and the consideration, then the activities are generally considered business or economic in nature. But when considering these questions, you do need to note that exempt supplies as well as taxable supplies are regarded as business activities. Next slide, please. So what is the impact on VAT recovery? Well, charities, like other businesses, will have an entitlement to recover VAT where taxable supplies are being made or intended to be made. It is important that a charity has the evidence to support this intention, and it should also be noted that VAT incurred that directly relates to non-business supplies is not recoverable. And if a charity is partially exempt as well, then there needs to be a non-business apportionment before the partial exemption calculation. The business test for VAT recovery does get very complex, and we'll have a quick look at the Longridge Tribunal case referred to on the slide, as this ended up in the Court of Appeal for resolution. So Longridge is or was a charity that runs water-based activities for children, providing canoeing lessons and such like activities, as well as some related tuition. The charity charged for its activities, but these fees were subsidised by grants and charitable donations. At the time, Longridge was not registered for VAT, but was developing a new training centre and believed the building services could be zero rated. This was on the basis that the development was solely for charitable purposes, as per Schedule 8, VAT Act 1994, and not in the furtherance of business. Now, because the payments being made, HMRC believes their activities constituted an economic activity, in which case the building could then not be zero rated, as would have been the case if it had fallen under Schedule 8. So obviously a 20% issue. The first tier and upper tier tribunals found the organisation was not operating in a commercial or business-like manner and was therefore not operating in the course or furtherance of the business, of a business. So potentially Longbridge was in a situation where they could zero rate the contract. However, HMRC took the case to the Court of Appeal, and this upheld the view that Longbridge's activities amounted to an economic activity, and therefore there was a liability to pay VAT in respect of building supplies received. Now, this decision was arguably centred around the context of the activity. Among these were the way that charges were set up to meet operational costs, as there was a reliance on donations and grants, and the extent to which Longbridge relied on volunteers to pursue its principal charitable objectives. But these were accepted at tribunal, but not at the Court of Appeal. It should be noted there was no special rule for charities. An activity can also be deemed an economic activity, even if the activity is not profitable. And the judges commented that it is generally assumed that an activity is an economic one if it is permanent and is carried out in return for remuneration by the person carrying out the activity. In addition, they believed there was a direct link between the money received and the activity, and in essence, the charitable concerns were irrelevant to the objective test, and were not enough to convert what would otherwise be an economic activity into non-economic activity. So the status of the activity to be conducted does impact on any VAT recovery, and your input tax could be subject to further restriction if VAT reliefs are removed. Can I move on to the next slide, please? So we talked about earlier on about we will be looking at goods and services that can be purchased without VAT. So in effect, we're looking at the relief of VAT on goods and services generally and how it affects charities. So advertising, supply of advertising can be zero rated rather than standard rated. That's the supply of advertising to charities. Even when the purpose is not to seek donations, but could, for example, include recruitment adverts. And these adverts can be in any media, newspapers, magazines, online, or cinema, etc. And this zero rating can apply to charities that are even not VAT registered. However, it should be noted that HMRC have recently adopted a more restrictive approach to this with regard to online adverts and social media. And what you need to be aware of is it depends how the adverts are being targeted. Where there isn't definitions around social media can be very complicated, and quite often when you have the pay per click situation, the adverts can be targeted based on behavioral usage and demographics, and some of these will turn the supply into a standard rated supply. So we would suggest that if you want to advertise in such media, that you research that area very carefully. Another VAT relief is where a charity can provide aids for people with disabilities. Now, this is where it supplies to charities of certain goods and services, which the charities then make available to people with disabilities for their personal or domestic use can be zero rated. And with that, we're talking about things like adapted goods, adapted motor vehicles, or building works such as ramps. And on this slide, we refer also to construction services. So as with the Longbridge case in a way, the construction of a new commercial property is normally standard rated. But if the building qualifies as a relevant charitable purpose building, the supply of construction services by the main contractor can be zero rated. So an RCP building is either similar to a village hall or is used primarily for charitable non-business purposes. But it must be remembered that any zero rating does not extend to the subcontractor. The subcontractor is making a standard rated supply to the main contractor, and the zero rating only ever applies to the main contractor who intends to use the building. From the main contractor to the client who intends to use the building. Next slide, please. So we'll have a look at some more reliefs for fuel and power. Now, for commercial users, the supply of electric, gas, oil, etc. is 20% VAT. But charities can receive these supplies at a reduced rate of 5% in various situations. Although quite often, charity has to issue a certificate to the supplier to claim this relief. So what the situations are is where we look at supplies of residential accommodation, such as a children's home or a hospice or care home, or where the buildings where there are only chargeable non-business activities, such as free day care. Basically, whether 60% or more supplies are for use on non-business activities, then the 5% can be applied. But you may need to arrange that with the relevant power supplier. We also refer to medical equipment. This is where the charity needs to be an eligible body, usually conducted in research activity, and this enables it to purchase medical equipment at zero rate from a UK supplier rather than standard rated. The equipment itself needs to be used mainly in research, or diagnosis or treatment of patients. And basically the funds for that need to be either charitable or from voluntary donations or contributions. But it should be noted that if the money is used for equipment that is not medical, such as a television purchase for use maybe as for staff room, etc., then that does not qualify. Quite often, the charity itself will have to issue a certificate to the supplier, and the HMRC have a format for that specified in a notice 7016. Next slide, please. I thought we'd have a quick look at relief of VAT on income as part of this process. So what we have, refer specifically to fundraising events. So if the income received is for a fundraising event promoted with the main goal of raising money for the charity, this can be exempt from VAT. The exemption will apply to the admission and any other income such as the sale of food or commemorative items. However, there's a limit on the amount of events any charity can run, of any funding events a charity can run in any financial year to benefit from this exemption. But it should be noted that any general admissions could be standard rated. There is a cultural exemption if the income is received in relation to entries to museums, galleries, arts exhibitions, or live events such as theatre performances. However, this service must be provided by an eligible body which is defined by HMRC as not-for-profit and essentially managed by volunteers. But it should also be noted that if the public are given admission to a premises without any payment, but a donation is freely given, then that money is outside the scope of VAT, so it does not attract VAT. This is even where you put in a suggested donation, but you don't insist on payment. Both follow the same principle that money is given freely by the donor, with nothing provided in return, and it's possible to have a two-tier admission system, where one is a standard fee subject to VAT, and a higher fee which is a split between a donation and admission fee. And the customer has the choice to pay, but it does all need to be clear. Now, a charity itself may also receive advertising income as opposed to expenditure in advertising. And if the charity sells advertising space in their own brochures, etc., then the sale is standard rated, except if the advertising space is given to another charity, in which case it can be zero rated. And in a publication, if 50% or more of the total adverts are placed by private individuals without reference to business, then all the advertising income can be treated as outside the scope of VAT. The problem with this area, of course, is the internet has changed everything. So we have to see how that develops with the HMRC. We also refer to donated goods sold by charity shops. So a trading branch of a charity can sell, hire, or export donated goods as zero rated, where the goods have genuinely been donated to the charity and they've been made available to the general public. But if the charity buys goods that it intends to resell, then the onward sale is VAT standard rated, unless the goods themselves are VAT zero rated. And also, if books with charities, that would relate to books, amongst other items. There is also a degree of VAT relief on sponsored challenge events. This is a situation when a charity buys places within a commercially organised event, such as a marathon race, and subsequently offers these places to individuals. So as long as the charity allows the individuals to take part, irrespective of how much money they raise, the full value of the money received from the competitor can be treated as a donation and is outside the scope of VAT. However, occasionally a charity will offer services to help that individual in the event they've entered. And ordinarily, these would be seen as benefits to the donor, which would usually change the donation to a taxable sale for VAT. But also, please note, HMRC do allow a charity to provide some modest benefits in these circumstances, such as a free t-shirt, advice, or energy drinks, so the donation itself can remain outside the scope of VAT. But when a charity gives away places in an event, and the individual must meet a target in order to secure that place, the target funding is regarded as a taxable supply at the standard rate. And any amount in excess of that would actually still be a donation. And another source of income that is relieved from VAT is the supply of staff between two parties. Now, usually the supply of staff is VAT standard rated, unless both parties are charities. If both parties are charities, the supply is outside the scope of VAT, so long as the employee is engaged only in the non-business activities of the lending charity and is being seconded to assist in the non-business activities of the borrowing charity. So not entirely, it is a bit more complex than it sounds, but there's scope for saving VAT on such linkages. Finally, we have the membership subscriptions. Now, HMRC do try and treat most membership fees as a single supply for VAT purposes, and this would be determined by the primary purpose or benefit. Charities can split the benefits of membership with VAT treatment of each benefit determined separately. So, for example, if you've still provided a magazine, that in itself would be zero rated. If part of your membership covered insurance for whatever reason, that would be VAT exempt. So there is scope for minimizing the amount of VAT you actually have to pay on your membership subscription, but it does need to be clear what the amounts relate to. Final slide, please. Okay, so I hope you find the content of this webinar of interest and helpful today, but I apologize that at the minute we cannot do a live Q&A aspect. I would ask that you feel free to email me at the address jruddell@jamescooper.co.uk or contact us through the James Cooper Creston website, www.jamescoopercreston.co.uk, in which case a member of our VAT team will get back to you to assist in whatever way we can. I just also want to say thank you for listening and taking the time today to participate in this webinar. Thank you very much.